We are resuming a recessed hearing in docket number W-1297, sub 14. This hearing is a virtual hearing by remote means of WebEx. Just to reset and reestablish, I am Tanola D. Brown Bland with the North Carolina Utilities Commission. And with me, joining me today are Commissioners Jeffrey A. Hughes and Floyd B. McKissick Jr. Let me have appearances and indicate who you are and who is with you for the record. And I will start with the complainant.
Good afternoon, Madam Chair. My name is Andrew Irby, IRBY. I'm attorney for complainant MRT-1-LLC. And sitting with me is a representative from MRT, Dan Timberlake.
All right, thank you. From respondent.
Good afternoon, Madam Commissioner. I'm Michael Janest for the respondent, Harker's Island Sewer Company. I do not see Mr. Mike Laws, who is our representative. As far as I know, he is working on logging into this WebEx session now.
So you do expect him to join us?
I do.
And that is fine. And the public staff?
John Little, staff attorney with the North Carolina Public Staff, and with me is Charles Junis, the director of the Water, Sewer, and Telephone Division for the Public Staff.
All right, thank you, gentlemen, for being here. Mr. Janess, do you need us to wait for Mr. Laws?
If the commission is prepared to move forward, I'm absolutely ready. Commissioner Brown Bland.
We are prepared. I just don't, if you feel that you need him or he needs to be here, I don't want to get too far down the road before he joins.
I believe I'm authorized to speak for him on all of the matters that I understand us to be talking about today. And hopefully he'll join us as soon as possible.
Do you have any ability to check with him just to be sure he's trying to join? If he's having any difficulties, he needs to get in touch with our IT.
Yes, ma'am. I've just sent him a text message.
Okay.
I have not heard back yet.
All right. Well, if we get to the point where you need him, we'll pause and let you try to tend to that the best we can.
Thank you, Madam Commissioner. And he has just texted me to say that he is trying to log in, but apparently is having some technical difficulties.
All right. Mr. McCoy, do we have any way to reach out to assist Mr. Laws?
All I have is his email. I could try emailing him again, and I'll send him another link, maybe an attendee link, and he can get in that way. So I'll send it right now.
All right, thank you. All right, gentlemen, I was hoping we would not have to be back here, but based on the progress, I was hoping we would not have to be back here based on the progress we had made at the time we were last together, but it doesn't seem that it's worked out that way. The commission is concerned that there hasn't been any progress since we were last here, and if I'm wrong about that, I'll give you each an opportunity to tell me more about it. But first, let's recount a little bit about where it appears we are. So on August, I believe it was August 17th, we were last here in the hearing room, and the complainant's case in chief had been completed. We recessed after the parties informed the commission on the record that within 10 days of that day, back in August, that the attorneys for the public staff, MRT, and for Harker's Island would work together to present a consent order for the commission's consideration, that within 30 days from that date, the commission would receive an application from the utility requesting authorization to seek financing. And it was my understanding that that was an element that had been requested as a way of establishing trust between these parties. And in the same 30-day time period, plus an extra day, I gave the commission would receive a status report about where we were on this and if anything had changed. Since we recessed, the commission received a filing on September 29th of a proposed consent order that recounted a settlement in principle. And that document itself indicated that the parties would, on or before October 6th, provide the commission with a status update regarding the tentative settlement that had been outlined and confirming that the process was moving forward. We, having not received a status report, it would have been my understanding that we would have continued with the hearing and it was supposed to continue and be here. Yet it's my understanding that Mr. Janess, you had not planned to be here as you had other matters scheduled. So I need to hear from you guys about what's been going on since we were last together and what, if any, progress has been made. So I guess I'll referee a little bit and give each one a chance to speak up. So I will start with the complainant.
Thank you, Madam Chair. Your recitation is not inaccurate. We did exchange drafts of the consent judgment, but admittedly, we're not, MRT-1 is not really driving the train with regard to filing an application for approval to borrow funds, until I think Mr. Janest and I spoke on Tuesday. I did not know the source of funds. I didn't know, they'd kept that pretty close to the chest. But since Tuesday, I've been informed of the sources that they anticipate applying for money for. I do not believe that Hisco has been in touch with Bill Foreman, the engineer, regarding sizing a system since August 17th. At the very least, my client has informed me that he spoke with Bill Foreman, and Mr. Foreman has not spoken with anyone at Hisco. So we're not 100% clear about what kind of progress Mr. Laws has made as far as designing a system, hammering down how much money would need to be borrowed. We were hoping that the status update today would provide us with that information. As it stands, we're ready to fund our part for the 28,800 gallons that would serve James Creek, and the money's ready to go. We're just waiting for plans and for permitting and approval so that we can put those funds forward.
All right, I'll come back to that in a minute. Mr. Janest, from your point of view, what's going on and why hadn't the commission heard from you within these timetables that had been established when we were last together?
Thank you, Madam Commissioner. As Mr. Irby just indicated, he and I did exchange drafts and get that over to public staff, and public staff has made their comments. So all that has been circulated, all that has been submitted. As was noted, the submission of the proposed consent order was fairly recent after receiving all the feedback from all the parties. And as soon as that consent order was agreed to and submitted, I spoke with Mr. Laws about getting in the application as soon as possible. And speaking for him, he immediately got in contact with staff. And I'm not sure exactly who he spoke to, but the question that he had was, there's no form application for what he's trying to do. He was instructed to submit a letter indicating the need for funds and the sources of funds. To my knowledge, he's done that and has listed at least 2 conventional sources of funds that he's pursuing and a third source of private money that he's pursuing, any one of which would suffice to bring the funds necessary for this project. So he has definitely been taking the steps that were contemplated. The I think something that we did not necessarily understand at the time of the prior hearing was that the information sought as to the ability to incur debt includes the direct source of the funding. And to get that, Mr. Laws has made applications for that funding from two different banks. And as I said, there's also a third option, a private party option for that as well. And so that was done in compliance with the consent order that's been submitted. That was timely performed, but getting the actual funds in hand is dependent on the banks sending their appraisers out, assigning appraisers, getting their appraisals, and completing the rest of their loan process. So I'm happy to answer any questions that the commission has, but I would point out that we have been working on this issue, and we have been working together with MRT's counsel to get the commission the necessary documents.
All right, and before I follow up with any questions, let me hear from the public staff. Anything that you have to add to about the process and where we are?
The public staff, I would just say, Your Honor, Mr. Laws did inquire of the public staff via email about the process for the form for submitting the financing, and responded, and the public staff responded that a letter detailing the financing obligations would suffice. At this point, I don't see anything on the commission's docket where that letter has been submitted, and have not received any further communication regarding or any further requests for help from Mr. Laws.
All right, thank you, Mr. Little. So the concern here is, and
Excuse me, I was just able to join. I'm sorry.
good afternoon, Mr. Laws. Glad you made it on.
Yeah, sorry for the delay. It was technical. I was just trying to get on, and it was just a struggle there, but I'm here. Sorry.
Prior to your joining, I've just gone over and heard from each attorney the status of where we are up to this point. So the commission is very concerned and, quite frankly, not happy that we left here and we had strict agreement about keeping us informed of what was going on. And perhaps there's some misunderstanding or confusion that the public staff is a substitute for the commission, but we're two separate agencies, and speaking to the public staff is not the same as speaking to the commission. If something is to be filed, it has to be filed in the commission's docket. So until now, we had no way of knowing and no indication that Mr. Laws or the utility was following through on its promise to seek the funding. And that's the kind of information that we wanted to know and be kept abreast of how that was going. Then you say you've exchanged drafts, but what came back to us that we received on September 29th appears to just be a restatement of what you told us here in the hearing room, which was an agreement in principle. And it does not seem to be a finalized agreement, and perhaps there's a lot more involved, but you left here saying you had a lot of work ahead of you, and that's what I expected you would be doing, is trying to come to terms and making something specific. So it seems as though some progress has been made. The parties have not walked away from their agreement here, and that's good to know. That means I'll consider that we're moving on track. But I need to hear what you have to say about why we don't have more than just the same agreement in principle. Again, I'll go around the table, and we're trying to make sure we get on the same page here. So I'll start with Mr. Irby.
Thank you, Madam Commissioner. So after we received a communication from Ms. Jarvis that that the document we submitted was insufficient to meet with the commission's expectations, I asked Mr. Jeunesse permission to put pen to paper on what I would call a settlement agreement that has a little bit more detail and suggest timelines uh, for funds to be an application for a loan to be approved, for a design system to be, submitted, for permitting to be submitted, so that there's a little bit more, I guess, there's a little bit more teeth to meet with the commission's expectations for updates going forward. I've not received anyone's comments back on that, but the idea would be to include those timelines, those very specific markers for us going forward so that we can start construction on a system, within the next 9 or 10 months. As I said, we're ready to go. In fact, we've gotten a quote for an 80,000 gallon per day system for $1.8 million, but we can't really move forward without, I mean, it's kind of Hisco's show. It's their system. We're just kind of providing money to produce our own capacity. So we're more than happy to take the ball and run with it, but we didn't want to put the cart before the horse. So I hate to keep throwing this back on Hisco and Mr. Jeunesse, but we're waiting on, I mean, they need to file the application, they need to secure funding, they need to help us design a system.
Mr. Irby, what was your
I'm sorry, go ahead.
understanding? What was your understanding, and why to this date didn't you take it on yourself to get a status report to the commission?
I chalk it up to attorney delays. I mean, when we would submit drafts back and forth to each other, like I got Mr. Jeunesse his draft of the we said 10 days, so it was going to be a week and a little bit more following the Thursday hearing that we had on August 17th. After that was a Thursday, I think I got him a draft of the consent order the following Monday or Tuesday. It took Mr. Jeunesse a couple of days to get back to me with his changes. It took me a day to get back to him to respond to his red lines, and that's when we submitted to the public staff. So I chalked it up to just attorney delays. Maybe we were over ambitious with estimating a 10-day time period to get that order submitted to the commission, but I do recognize that it was a restatement of what we said in open court. It was not a document that included what I would prefer to have included, actual measurable markers to be met by certain periods of time so that we, what we hope to avoid candidly is a status update saying things are moving forward. Well, we're waiting on, this application. I'd like to put certain deadlines in there that allows us to gauge whether this is actually moving forward or whether we're just, talking about it moving forward, if that makes sense. So
Right,
that's the draft. That's the draft that I've circulated, and that draft candidly would include the signatures of not just the parties, but the attorneys for the parties, so that we're all on the hook. It's not just a consent order to be signed by the commission. I'm hoping that we can get everyone's signature on a document like that or that relatively soon. Benchmarks.
Mr. Jeunesse, your view of why we hadn't moved beyond the agreement in principle to date?
Madam Commissioner, I think that the first point to recognize is that we worked hard in our last meeting to make sure that the agreement was fairly comprehensive. So the general statement in open court was actually fairly specific. So the subsequent agreements embodying the same or similar points is partially due to some, I would credit Mr. Irby as well with that being, fairly comprehensive up front. I do take his point that the commission would like to see, and I understand that Mr. Irby would like to include some additional, what he's described as benchmarks, and I don't think that there's any objection on our side to including those benchmarks. What those benchmarks will actually be, to be blunt with you, we need a little bit of time to speak with Mr. Irby and MRT about what is reasonable there. The thing that I don't want to inadvertently commit to and then not follow through on, as far as the commission, is there are quite a few dates that we can't control. So for instance, we can control the submission of applications for these loans from the banks that we referred to earlier, but I can't control how long it takes the banks to get back to us with that funding and making that funding available. As far as the sizing of the system, that's already been done. That work, and I know there was a reference earlier to whether Mr. Laws had spoken to his engineer about sizing a new system at this point. That is work that was done prior, and quite honestly doesn't, we could check that box now, that the sizing of that system and the approximate pricing of that system is work that's already been done. I'm in accord with Mr. Irby in terms of getting a settlement agreement between the parties as a method of resolution, and I don't have any problem with a more formal reporting structure to the commission. I would ask for some guidance from the commission on what that should look like. If the commission wants a filed document on a regular basis, of course,
right.
we would
So-
appreciate some guidance on it.
So gentlemen, let me say, the commission takes seriously what you represent to this forum, and what was represented was that 10 days after we were here, certain things were going to happen. 30 days after that, certain things were going to happen. If they're not going to happen, you guys practice law, you know you need to come back to the forum, explain why they're not happening. We hit a snag. It was bigger than we thought. It's more difficult than we thought. I had a particular personal issue, whatever the issue may be, and then you come back and you inform the court, or the commission in this case, of that, and you ask for additional time. You don't leave the commission strung out here not knowing what's going on. And Mr. Janess, as far as you knew, this hearing was still on for today, and then when we went to have it, you weren't available to come here. The commission falls in line just like any other court. The priorities and the timing of which courts take precedent, the same rules apply. And I just want you all to know that this is a serious matter and we take it seriously. This matter's been hanging out here about 3 years. We want it moving along. We don't want it just hanging on. That being said, we agree with you that the appropriate and the better means to get this resolved is by agreement and settlement. So when we left, what I was anticipating, and maybe it had not been made clear enough, but I'm anticipating you all will work out what is called a settlement agreement, that you will come back with the settlement agreement that contains some of the specifics that are needed to resolve all the issues that have been raised here, and to let go of the issues that you agree you can let go of. Enumerate what those are. File it as an agreement, and the commission would incorporate it into an order, whether that be a consent order or otherwise, and we would then go from there. The agreement would be something that each party could hang its hat on in terms of the rights that you agreed on as basically a contractual matter. So we're disappointed that we didn't hear back and that we're just now hearing back. So what we would like to happen, just in a general way, is a finalized agreement between you. And that involves more than just saying the percentages of what you'll contribute to the 28,000 plus, I think it was 800,000 gallons of capacity that would be reserved for James Creek. We need to have the commitment from the utility that if all the conditions that you agree on are met, that this service will be provided and will be reserved unto James Creek. You know, the promises that are being made between you need to be spelled out and specified. If this takes longer, then you need to let me know it takes longer. If I'm not giving you enough time, I need to hear from you on how much time is needed. But we want to see this to continue moving on. We also would like some agreement that all the property or equipment that's necessary will be under the control of Harkers. I would imagine a legal property interest of some sort is necessary before lenders will want to provide the funding. So you need to work that out in terms of where this new facility is going and how it is that Harkers, the utility, will have control and access to it. And of course, we need to be clear on how much capacity is being reserved to James Creek. And so what I want is, I would say from this time going forward, we would like to have an executed settlement agreement regarding all the outstanding issues in the docket. At this point, I would ask, I'll give you a chance to be heard in a moment, but at this point, I would ask that you provide that within 30 days of this date. And within that same 30-day period, we have either a status report or an actual application for authorization for the utility to seek that financing. And if no agreement has been reached within the 30 days or within some agreed upon time when we leave here, whatever is ultimately the final outcome of today's hearing, then we will set this matter back on for trial and we will try it out. So I need to hear from you whether that sounds workable. I'll start with Mr. Janess.
Thank you, Madam Commissioner. It sounds reasonable to me. I anticipate that there may be a couple of things that need to be put into the agreement that have either flexible timelines or conditional timelines, because there are steps that go one after the other. But I actually think that we're much closer to that final agreement than may be apparent by what's already in place. I think that we know exactly where the facility will go, who will owns the land underneath, who will own the facility afterwards. Those issues I think that we can resolve between us very quickly. And any issues about timing, I think that we can come up with some both reasonable and concrete solutions for that to include in a settlement agreement to present to this commission. And I do also believe that 30 days should be sufficient, unless Mr. Laws tells me otherwise. And I apologize, but I have no way of conferring with him before speaking on that matter. But unless Mr. Laws tells me otherwise, I believe 30 days should be sufficient.
Mr. Irby?
It's hard to disagree. I think 30 days is incredibly generous. I wouldn't have minded if the commission suggested 4 weeks, which would put us at October 27th as opposed to November 6th. But once again, I don't want to force Hisco into a timeline that they can't meet.
All right. Now, on a separate matter, and I just want to know if anybody thinks this affects what we're trying to do here in this case. But the commission is aware that a moratorium has been placed on the Harkers Point facility. And I don't know that impacts, but I want to know, I mean, are you all aware of that and how you think it may impact or not impact this matter that we're trying to resolve now. Mr. Irby?
Yes, ma'am. I was informed of the August 29th letter to Harker's Island Sewer Company, the notice of violation and enforcement actions dated August 29th, and the notice of violation dated September 15th. I was notified of them about an hour and a half ago. So I have not had a whole lot of time to digest. I don't want to throw anyone under the bus. I will say I'm upset that I'm learning about it now, as opposed to, when the letters were issued. I don't necessarily think it changes my calculus. One of the provisions I put in my proposed settlement agreement was Harker's Island Sewer Company cannot expand capacity until a new wastewater treatment facility is built and capacity is provided to James Creek. So they can't expand to new franchise territories, can't obtain any new customers. We're first in line so that this new system can get built partially with our money. So it doesn't necessarily change my calculus. In fact, it's almost like DHHS took, one of my enforcement mechanisms away from me and decided to do it themselves. I'll be curious to hear what Harker's Island Sewer Company has to say about them.
Mr. Janess?
Yes, ma'am. Thank you. And I'll let Mike Laws speak to anything that he feels that the commission needs to know about his conversations with Mr. Berkowitz at DHHS. But it's my understanding that the two issues are related to the same core concern, which is that facility needs to be substantially updated or replaced. And that's what this agreement, as Mr. Irby just said, that's what this agreement facilitates. And so the two issues, well, I don't think that the other matter impacts this matter. I think that they'll both be resolved by the same action on our part.
All right, Mr. Little, anything that you need to add?
Yes, Your Honor, thank you. The public staff is very concerned upon learning this information. The main focus is on the capacity of the present sewer plant, and with what essentially operates as a moratorium, at the very least, getting plans submitted to DHS and other regulatory agencies is going to lengthen this process longer than already contemplated. And the other issue is that there are
Mr. Little,
Yes,
what, just to stop you, why do you say it will lengthen the process? The plan
believe
is
that
to build a new facility, as I
those
understand.
plans will have to be submitted to the DHS and approved by the DHS, which is an extra step that I don't know was contemplated with the settlement agreement after the last hearing. So I think a 30-day, and I would assume that Mr. Laws, Mr. Nest are aware of that and are working towards that, getting those
Right,
plans.
they're aware now, so that would, I would presume they can work that into their settlement agreement if need be. But go ahead, continue.
Yes, but I think at the least it's going to lengthen the process beyond what was contemplated at the previous hearing. And it also, it's not only that there's a capacity issue, there are other violations of exceedances of nitrogen discharge and other things like that. And truthfully, upon learning of these violations and the notice of violation, especially, the public staff has concern about Harker's Island's ability to operate and manage the wastewater treatment plant. And Mr. Janast, on behalf of his client, Mr. Laws, has it seems like they're working towards an expansion of capacity, but with these other violations, I don't know. I will stop and say that we are concerned about the ability of Harker's Island to continue operation of this plant, this wastewater system.
So, Mr. Little, will the public staff be making follow-up contact with the utilities as part of its usual monitoring of the regulated utility,
Yes, we will, Your Honor.
having become aware of the notices of violation?
Yes, I think you'll see the public staff take a little bit more of an active role in this case. And now that we are under,
And for now,
now
that
that we're aware
concerns
of these
the,
violations, and we're contemplating additional action outside of this complaint case we haven't decided on any other further course of action, but there are discussions about other actions the public staff could take.
and so for now, that concerns the existing customers and the existing facility and the service that they will have between now and the time, presumably, that we get to a new facility that will have to go through the approval process, as you meant, permitting approval, et cetera. Is that correct?
Yes, ma'am.
All right. Anybody else have anything else to add with regard to the notices of violation and how they might impact what we're planning with regard to the complaint?
I do, Your Honor.
That's Mr. Lyles. Mr. Lyles, could you turn your camera on?
Right. That's one of the.
There
Okay,
you go.
got it?
All right. You know, your attorney has spoken for you, so but if you think there's something else that we need to hear, we
Yeah,
will entertain it.
the notice of violation,
You
there
hear?
was 4 items to that, and 3 out of those.
Mr. Lyles, can you get closer to your microphone? We're having a little trouble hearing you.
Yeah, I'll turn it up here. Okay, is that better?
Yes.
Okay, the notice of violations, there was 4 points there, that we could control, I guess you'd say, and 3 out of the 4 have already been rectified. It was a matter of, operator, a backup operator, and a new, testing lab, and all those have been, completed, executed. So the only one that it's still in process is a denitrification upgrade to the plant. Half the plant, this plant has 2 what we call trains. It's 2 separate chambers that treat wastewater. And one of those 2 have been upgraded with the denitrification system. The second train is in process. That is something that we cannot do during summer months because of the flow that we're experiencing. We are a resort community, so we have to do this on off-season time periods, and that is upcoming, and we will switch over and do the second train. I have appealed to Mr. Berkowitz to forego that second train in lieu of that, going through that expense for the utility, since we should have a new plant coming online in the next year, or to be included in this agreement, the time frame. I don't think that notice of violation has anything to do with this, or should hold up this agreement or this process. Matter of fact, it should bring along DHHS to be diligent in their reviews and help us with getting this matter. As we concluded in our hearing, this plant is 25 years old. The engineer stated in the permit itself that its age is 25 years. I'm putting very expensive Band-Aids on a plant. There's no risk to any kind of spillage or anything like that, but they are expensive Band-Aids that the utility is incurring, and sometimes myself personally, expenses to keep this thing running and to keep it in operable status. In the meantime, I'm under a moratorium, which and have been under a new connection moratorium for approximately 18 months now through the actions of Mr. Berkowitz, which limits the funds available, to do upgrades. So one side, we're getting financially squeezed, and but we're been urged to do these denitrification upgrades, which are expensive. We have to go inside the plant and weld in metal chambers and new additional pumps and aeration. It's an expensive process. It's about 30 to 35,000 per train. So that is that is something I've asked Mr. Berkowitz to forego. The plant is operating, as far as capacity is concerned, it's within the capability of train number 1 or North Train. It is within the capability and within its design capability. It's operating properly there, with the exception of the denitrification. That system has just come online, so our lab results should reflect that soon. And if the civil engineer's design and Mr. Berkowitz's approval of that design being adequate, if they hold to be true, then item number 4 is checked off with the denitrification notice violation. So the notice of violation is, if you want to attach numbers to it, is 75% complete.
All right, Mr. Janess, did you have anything you wanted to add to what your client has said?
No, ma'am, thank you.
Okay. All right, well, here's what we're going to do. I'm going to set a deadline of 30 days from today that you'll have filed with the commission an executed settlement agreement regarding the outstanding matters in this docket. How you propose to proceed and what you're going to hold each other accountable for. If you can't reach that agreement, then each party at that same 30-day time frame should submit a separate status report explaining why the settlement wasn't reached and what happened, or whether you need more time, indicating to the commission what kind of progress, or that some real progress is being made. You'll explain what issues remain and have not been resolved, and if you have resolved some, we'll be interested in hearing those as well. We would like to have some indication of when it's reasonable to have at least had conversations with the engineer and how that's going. We would like also to hear from you what's happening with the lender process in terms of the 20% that Harker's Island utility has agreed to pursue. So we'd like to have indication that forms have been completed, submitted, and to whom they are being submitted, or from whom you've heard from. Unless there's some reason that it's inappropriate and you don't want us to know, indicate that as well and what the reasons for that are. And if additional time is needed, also indicate that, what the reasons for that is. Ask the commission for leave for additional time. I'm trying to think to be sure that we cover the bases here. We understand that when I'm setting these directives, I intend for this to be filed through the commission's docket system so that we have an actual filing within 30 days of today. Hold on just a minute. I'm going to take a 5-minute recess to be sure that I have the bases covered here. Madam Court Reporter, 5-minute recess. Everybody sit still. Hold on.
Mr. McCoy, I am almost out of battery on this laptop, so I'm attempting to connect to the meeting on my phone, just to give you a heads up.
Okay, I'll look out for you.
All right, I heard somebody has a low battery, so I'm going to try to get us wrapped up here. Mr. Janesh, you indicated that some financial information had been submitted. So I want to be sure that I understand that. Do you think you submitted that to the commission or to the public staff?
Madam Commissioner, based on what Mr. Laws said earlier, I'm not sure that that has been submitted at this time.
All right.
I'll ask him to speak to that.
I'm asking because if you thought there had been and we have not received it, so I was going to ask for people to double check and let's make sure that that's cleared up. But Mr. Laws, did you have anything to add?
Yes, we did send a statement in, just declaring that we would be pledging company assets. After reviewing the regulations, it seemed like that was a statement that needed to be made. And we did that on Monday. Maybe no, it was Tuesday. We overnighted it. It should be in process. It should be in possession of the commission or of the public staff or the so that was done, and we've
You
also
know to
hired
whom it was
appraisal.
addressed?
Excuse me.
Just we want to be able to track it down. Do you know to whom it was addressed?
It would have been addressed to the chief clerk.
All right, very
Yeah.
good.
Yeah, and we also have spoken with and scheduling an appraisal under the direction of the lender.
All right.
And so the property, as well as some of the assets, will be appraised to, secure the loan for $250,000. That was our projection of the cost of the plant, our 20%.
All right. So from what has been stated here on the record today, it does appear to me that the parties have been attempting to take steps to act upon what was agreed upon when you left here. And that is a good thing, and the commission is pleased with that. What the commission is not pleased with was the failure to make sure that we are getting some regular updates. So in addition to what I've already stated with regard to 30 days from today and what needs to come in. After that, I'm going to impose every 45 days from there out, give us some indication of the steps that are being made up to whatever you're able to agree upon, which we'll hopefully be learning about within 30 days. So the first status report after the 30-day agreement comes in will be 45 days later. So in essence, 75 days from now will begin a series of status reports. Stay tuned. The commission may adjust. You may request the commission to adjust that schedule of reporting, but we want to know that constant, consistent progress is being made to get this matter resolved and to get this complaint dismissed. So I'll say thank you all for continuing to work in the background. Just be sure in the future to keep us informed. And Mr. Janess and, well, all three of Council, Janess, Mr. Irby, and Mr. Little, you have the email of our staff attorney. And if you need to make contact specifically with the commission, you got unanswered questions, you can start there with the staff attorney, Lynn Jarvis, and you'll get some guidance about the next step you need to take. But otherwise, we expect you to abide by what's been stated here. Are there any questions? Is there any confusion? Let's clear it up now.
Madam Commissioner, I just have one question, just to make sure we're all on the same page regarding the arithmetic. Mr. Laws just made reference to $250,000 to cover their 20%, but that would build a plant that's only 28,800 gallons, not a larger plant to replace all of the existing capacity. So if we could hammer down what Hisco's plans are for building a new plant, my arithmetic shows that in order to build a system larger than the 28.8 that would serve just James Creek, it would be substantially more than $250,000.
Yes, Mr. Irby, but the way that I read what you submitted as the consent order, which was a rehash of the agreement in principle, I believe the 20% did pertain to the 28,800 gallons. There would be other financing that are needed for the plant. I'll let Mr. Janess speak to that, and if it does concern the plant in full, I would ask that you work with that in terms of the agreement that you're trying to hammer out. But Mr. Janess, do you have a response?
I believe the commission is correct on that point, that the 20% that is required to move forward is as with the 80% required from MRT. Both of those numbers apply only to their respective portion of the 28.8 to be reserved for James Creek. It is my understanding that there's also total replacement of the plant or additional capacity beyond that is the responsibility of Hisco and is outside of the scope of this agreement. If Mr. Laws meant that number differently, I invite him to correct me here on the record.
I agree with you, Mr. Janest, and I agree with the commission. We are all under the same understanding. I just didn't know if Hisco would need to provide an application for that additional expansion, the additional funding beyond 28.8, or if they're allowed to borrow money without submitting that application.
I think any time that the utility is seeking to take on additional debt, they do come to the commission for approval. But that, again, that's a separate part of this complaint. If you need that to be addressed in your agreement, again, I believe that's something that you all can hammer out as you work your settlement agreement.
I understand, ma'am. Thank you.
Any other questions about what you need to do? Gentlemen, I want everybody, I don't mean to overharp on this, but this case has been out here for a while. And there have been a number of continuances for different reasons. Commission made its own decisions about whether to allow those. So we're not stepping down or back from those. But I do, going forward, want you to take this commission seriously and understand that failure to abide by valid orders of this commission can result in penalties and sanctions. We hope not to go there. We don't expect to go there, but I want you to understand the forum with which you're dealing. Any questions?
No, ma'am, Madam Commissioner. Thank you very much.
No, ma'am, none
Commission-
from none from MRT.
Very good. The commission is under the impression that overall, since this docket was filed, and including since August 17th, it's been lenient with you because, again, we agree with you. We would like to see you all come to your own resolution and get this matter resolved. If there's nothing further at this time, Commissioner Hughes, we did not hear from you. Did you, since you are not here in the room with me, did you have anything that you needed to add?
You covered it all, Commissioner no, man, I'm good.
And Commissioner McKissick, did you have anything that you needed to add?
Nothing I needed to add, Commissioner Brown Bland. I think things we discussed were included within your order.
All right, we thank you for your time, and we will be adjourned.
Thank you to the commission.